Hello everyone, welcome to Immigration Fridays. I'm your host Prashanthi Vedi, and today we're going to talk about a pathway that a lot of people use to get their green card. That's getting a green card through marriage. It's a pretty standard route, but it requires precision and thorough understanding of US immigration laws, particularly because of the significant updates in 2025. So let's begin by understanding the fundamental eligibility criteria for a marriage-based case. First, there must be a valid and bona fide marriage. That means that your marriage must be legally recognized in the place that it occurred. And secondly, it must be bona fide, meaning that it cannot be a scam marriage or a fake marriage that you have gotten into simply to get immigration benefits. Now remember, every marriage-based case is considered to be a scam marriage, considered to be a fake marriage, and we have to prove otherwise. So the burden on proof is on the applicants to show that it is a valid and bona fide marriage. Second, the sponsoring spouse, whom we refer to as the petitioner, must be either a US citizen or a lawful permanent resident. Third, the foreign national spouse, known as the beneficiary, must be admissible to the US. That is, they shouldn't have any past medical examinations conducted which will disqualify them or make them inadmissible to get a green card, or they shouldn't have any criminal records against them, no past immigration violations. This will make them inadmissible. Finally, the US citizen LPR spouse must demonstrate the financial ability to support the immigrant spouse. This is done by the I-864, the affidavit of support. You have to show that you make more than the poverty guideline, and you have to show that depending on the size of your family, there's a chart which you can look at, which is attached to the I-864 under instructions, and that will give you an idea as to how much money you need to make depending on the size of your family. Now let's look into who is eligible to file these applications. So as we discussed earlier, US citizens and lawful permanent residents are the spouses, are the petitioners, and they are eligible to file for their spouses, and they are called the beneficiaries. The process can follow two main paths. If you're in the country or if you're outside the country, it depends on whether you're in the country or outside the country. If you're in the country, it would follow the path of adjustment of status, which means that you would file an I-130 and an adjustment of status, which is a 485. And if you are a US citizen spouse, since it is current and there is no visa number availability requirement, as there is no constraint with reference to the visa numbers for a US citizen spouse, you can file the I-130 and the 485 together. But however, if you are a green card holder, then you will not be able to file both together. You will have to file them separately because you'll have to file the I-130 first. And if the visa number is available, of course, you can file concurrently. But if it's not, then you'll have to wait for the visa number to become available and only file your I-130. So that's the difference between getting married to a green card holder, which comes under F2A, and getting married to a US citizen, which is an immediate relative. Let's go through the process for AOS. As I was saying, AOS requires the filing of an I-130 along with all valid documentation, passport, proof of relationship, proof of status, and the fee for an I-130 as of July 2025, at least, because this keeps changing, is $675. As I said, you can concurrently file your 485 or adjustment of status. The form is called 485, and you can file this along with the I-130. Now, you can also file a 765, which is the employment authorization document, which allows you to get a work permit while your 485 is pending. And you can file for advance parole if you want to travel. Remember, you cannot travel without advance parole, and if you do, then your adjustment of status application gets denied. So please keep that in mind. Another crucial form to be submitted is the medical examination form, the I-693. This should be filled out by a civil surgeon. That is, and if you go to, there is a 1-800 number that you can call, and you see who are the recognized or approved civil surgeons recognized by USCIS, and they will fill out the I-693 and they have to seal it and sign it and give it back to you. The fee for a 485 is 1440 presently, and the fee for I-765 is 550, but it is 260 if you're filing based on a 485. Or sometimes maybe you don't even have to pay the fee if it is not for adjustment, because remember the 765 can be filed in various situations. But since we're talking about adjustment here, if you have a pending 485 or if you're filing a concurrent 485, the fee is 260 for the 765. For I-131, the fee is 630. This is all as of today. So please make sure that you look at the website, the USCIS website, to see what the fee is on the date that you're filing. And remember, separate fee for each form. You can't combine the fees into one check. The next step after filing your 765, I-131, 485, I-130 is you'll get a receipt notice. This is an official receipt notice from the USCIS to inform you that the checks have cleared and that the case is now pending. Then you'll get a biometrics appointment notice, and you'll have to go get your fingerprints taken, and you'll have to sign, and you'll have to get a photograph taken. Then work permit, EAD, you might get that approved if it's filed concurrently. It usually takes a few months, and this is supposed to be an interim benefit. That is, you're supposed to get it while your green card case is pending. But sometimes you might get your green card even before you get the EAD because the EAD gets denied. And if the green card comes faster, then that might be the situation that you'll encounter. The next is you'll have to face an interview. Most marriage-based cases are interviewed. Last year, under the previous administration, we saw that even marriage-based cases were being waived. The interview was being waived. But I think this year the scrutiny is much higher, and they will most probably interview you if it's a marriage-based case. Both spouses must attend together, and they must be prepared for a detailed set of questions about your relationship. And they might even do a Stokes hearing, that is separating both the spouses and asking them questions separately. So that's the interview process. And then after all this is done, there will be a decision. It'll either be an approval, it could be a request for further evidence, or it could be a denial. If it's an approval, then you'll get the green card for 2 years. It's a temporary green card, and within the expiry of the 2 years, within the 90-day period of expiry of the 2 years, you'll receive a conditional green card, and within the 90 days, you'll have to apply for a permanent green card. And that's a separate process, removing of conditions, and you'll have to do this jointly along with your spouse. If you're not married for some reason during that time, if you're divorced, then you'll have to file for a waiver to file jointly, and there has to be reasons as to why you're filing separately, and you have to show that the marriage was bona fide at least when it existed. After this is done, then you'll get a green card for 10 years, and then you can keep renewing it or apply for your citizenship. Now let's look into the filing process if the spouse is outside the US. This is consular processing. Here also you will file an I-130. Processing time is the same, about the same. The current fee is the same, 675. Once the I-130 is approved, the case is then sent to the NVC, the National Visa Center. The National Visa Center collects all the necessary documents from you. All this is done online. You have a username and password, you log into their system, you upload all the documents, all the civic documents, police clearance documents, marriage certificates, birth certificates. You pay the fee, you fill out a DS 260, the form, and you also fill out the affidavit of support. This shows that your petitioner has the ability to support you. You'd have to also have to do a medical examination at the consulate. Um, the consulate will give you a list of physicians, and you'll have to get the medical exam done then. And then you'll have an interview at the consulate, and they will issue you an immigrant visa if it gets approved, and if all goes well. And you will get again a conditional green card once you come into the US, and the same rules apply to remove conditions. Important pointers for you if you're filing in 2025 that you have to be aware of. The procedural updates in 2025. There have been some changes, and these updates are crucial because ignoring them can lead to significant delays or even denial of your case. Firstly, mandatory use of the latest editions of the forms. Please make sure we have new forms as of April 3rd, 2025, and you can only use those forms. The 485 forms have changed, and they also look very different, so please look at them carefully and answer all the questions correctly. Separate payment of fees for each form. As of July 2025, new fees are in effect due to the HR reconciliation bill. So please make sure you know what the fees are as of date, and pay the right fee and pay separate checks for each form. Don't combine it into one check. As we were saying earlier, the medical exam is necessary, but now they have made it mandatory that as of December 2024, so that's almost the end of the year last year, you have to submit your medicals along with your adjustment of status application. Earlier, people would submit the adjustment of status and then wait for an RFE and then submit the medicals. That will no longer be acceptable. Please make sure that you submit medicals along with your adjustment, otherwise your case might get denied. As of 2025, there is also increased scrutiny on the marriage-based cases with reference to the bona fide status of your marriage. And they're looking at evidence to show that the marriage was a bona fide marriage. So always make sure that you send in all your documentation to show that it's a bona fide marriage, and there are joint documents that need to be sent in, and we can discuss that a little later. Another update is the COVID-19 vaccine is no longer needed as of January 2025. So the medical exam would not require you to take a COVID vaccine. Now let's go through some tips on how to successfully file your marriage-based green card. Number one, for proof of bona fide marriage, which is absolutely important, USCIS wants to see evidence of a genuine shared life. So you have to gather extensive and diverse documentation to demonstrate the authenticity of your relationship. This includes joint financial documents. It could be a joint bank account, could be joint credit card statements, joint utility bills, insurance documents, any health, auto, life insurance, any joint investments that you've made, shared life arrangements such as lease together, property deed that's on both names, again, utility bills of the place that you're staying, mailing address showing that you live at the same address, photos and communication, photos taken during the marriage or before the marriage, after the marriage, showing photos with family and friends on vacation, photos commemorating various celebrations, tickets or travel itineraries if you've traveled together. Screenshots of calls, texts, or emails can also be submitted as proof of a genuine relationship. Affidavits from third parties, sworn statements from friends, family, religious leaders, people in the community that know you to that can attest to the fact that it's a genuine marriage. If you have children, then of course that shows that it's a genuine marriage. So birth certificates of any shared children, their school records listing both parents is very, very useful to show that it's a bona fide marriage. That's number one. Number two is another tip. The second tip that I'll share is meticulous attention to detail on the forms. And this is why, in many instances, people who file on their own encounter problems. First of all, make sure you use the correct forms, the latest edition of the forms, because the forms keep changing. Go to uscis.gov to make sure you're using the right forms. Ensure that each form has its separate payment. Don't combine the fees. Put the correct fee in it. Write the check correctly. And then the form itself, especially the 485 form, and even to some extent the I-130 form, is very complicated and convoluted. And the forms often say that if this applies to you, if yes, then fill this out. If no, then go to question 7. So it's sometimes if you're not familiar with the form, you might just leave it that particular column blank, thinking that it doesn't apply to you. So go through everything very, very carefully, and it's not very well written, unfortunately, so can be confusing as to whether a particular column or a particular check mark applies to you or not. Number 3, for tips, I would say organize your documents clearly in a logical and easy to review manner. Use cover letters, tabs, indexes, so that the officer does not miss the document and again send an RFE for a document that you might have already submitted. Number 4, in tips, prepare thoroughly for your interview. In 2025, you can definitely expect an interview. Both spouses have to attend. Be ready to answer questions with reference to your relationship, how you met, your daily routines. Always make sure that you're honest, consistent, and genuine in your responses. Go through your entire application. Go through the possible questions that they will ask. And if you have an attorney, they will definitely do a mock interview with you so that you're prepared on how to respond to the officer, and also make sure you carry your documents in an organized manner so that your original documents, so that you won't have confusion once you go for the interview, and you can give them without having to look for them. Number 5 in tips is address red flags proactively and do the research and come prepared with to answer any difficult questions. If there are aspects of your marriage that might raise questions such as significant age difference, a very short courtship, maybe prior marriages, uh, immigration issues, um, significant disparity in cultural backgrounds. Make sure you get that extra evidence, and again, be transparent and be consistent in your answers. Now, number 6 in tips, consider using legal counsel. While you can file on your own, an experienced immigration attorney can provide you invaluable guidelines and guidance in your filing. The attorney can ensure all forms are correctly filled out and the latest editions are used. The attorney can help you identify and organize the most substantial evidence for your case. They will proactively identify and address potential issues or red flags specific to your situation. They will prepare you thoroughly for your interview and include mock sessions, respond to any request for further evidence, respond to notice of intent to deny, and overall give you uh, confidence in your application and put you at ease, because this can be a very stressful process. Number 7, with reference to tips, please be aware that timelines can vary significantly. For US citizen immediate relatives, since there's no visa backlog, adjustment of status can take about 9 to 12 months. EADs can take about 2 to 5 months. Consular processing is much longer because first you're filing the I-130, which takes about 10 to 14 months. Then you go through NVC processing, which can take about 4 to 6 months, and then you wait for your interview, so that the whole process can take about 2 years. For spouses of permanent residents, since the visa numbers are not available under F2A, may not be available. The I-130 itself takes 10 to 15 months, and then you could be waiting for 2 or 3 years or 4 to 5 years, depending on which country you're from, for your priority date to become current. Always check the official USCIS processing times. They have a great tool with reference to the processing times, and even though it's not always accurate, it gives you a ballpark um, at least amount of months that your processing can take. And finally, a quick note for those who receive conditional green cards. If you're married for less than 2 years, then you'll receive a conditional green card. If you're married for more than 2 years and then apply, you'll receive automatically a permanent green card. But please remember that you have to file your I-791, I-751 or removing of conditions petition within the 90-day period before your conditional green card expires. And this requires you submit more documents, ongoing bona fide marriage documents. Failing to do so will result in termination of your green card and you'll have to reapply. So getting a green card through marriage is a significant step, and with the right preparation and attention to these 2025 updates, you can navigate this process successfully. Thank you for joining me on Immigration Fridays. If you found this information helpful, don't forget to like, subscribe, and share this video. See you again next week. Goodbye.